Vot sunt mai răuti. Da, canti vot.
I seek your lordship indulgence in mentioning item number 12 of the hearing list, my lord. Even though this is a fixed matter, my lord, we understand that there is a fixed matter before this item number 12, which requires
This was listed today
Which will take
on the
time, my
request of the
Yes,
counsel
exactly,
for the
my lord.
petitioner.
my lord.
What is the point of making such request? If you are adjourning day by day like that, we'll adjourn it for a long date.
After a week, my lord.
Why should we list it after a week? You'll adjourn it again like that. Yesterday, someone had mentioned, one of your colleague had mentioned, that should be tomorrow.
My lord.
So we fix it today,
My lord.
and here again you are mentioning for another date.
It is our understanding that, my lord, the hearing matter beforehand will take time.
We'll adjourn it for 2 weeks.
My lord.
Paid for by learned counsel, Mr. T. Lal Zakima, for the petitioner. Matter stands adjourned for 2 weeks.
Deeply obliged.
I seek your lordship indulgence in mentioning item number 14. On behalf of my senior, Mr. Lertran Puya, he's not able to attend the court today due to some personal difficulties. I have also taken the consent of state respondent,
Okay, similar order, 2 weeks. You just mentioned your good name?
H. Lerosfella.
H. Lal what fellow, okay? Yes, 2 weeks. Any other mention?
For motion, item number 1.
made to the Lordship.
Yes.
My Lord, before I proceed, my Lord, the matter which is under review before your Lordship is on a very limited ground, my Lord.
What is that?
Fundamentally, my Lord, we are very much satisfied with the judgment your Lordship has rendered in this particular case, my Lord. But due to a recent development, my Lord, which was post the judgment, some information was gathered from the client, I mean to say, the review petitioner, and which has perhaps, my Lord, will have necessary for this honorable court to look into this aspect, my Lord. Regarding, my Lord, this case in which your Lordship has dealt with a tender process in which, my Lord, the lighting, this setting up of and commissioning of floodlights in Indo-Bangladesh border was a challenge put to challenge by us, my Lord, saying that...
What is the ground for review? Just tell me that.
Yes, so the ground for review is, my Lord, at the time when the matter was heard before your Lordship, my Lord, a submission was made by the councils appearing for the NBCC authorities that the work has substantially progressed, my Lord, and that 8 months have gone, my Lord, and the project is of 15 months. And, my Lord, the party, the contractor who was awarded the contract is in the midst of executing the work. And on this particular premises, your Lordship was pleased to not intervene in the matter and allow the parties to continue with the work that they were executing. Because, my Lord, it involves national security as well as, my Lord, interests of general public. Now what happened, my Lord, post this judgment, we as petitioners made an attempt to find out the realities at the grassroots level, my Lord. What is the status of this project which they claim that has been completed or was more or less was executing, and 8 months have gone, my Lord. But glaring, my Lord, there has been some revelation, in which case, my Lord, I would just like to take your Lordship to some of the photographs we have taken in this site of the project, my Lord.
No, you just take me to the ground taken by you,
Yes,
specifically on this point.
Yes, my Lord. Kindly, Lordship, may kindly come to the ground at page 17 it starts, 18 is
The grounds taken by you is like essay writing.
my Lord.
Well, how can it grounds be 2-3 pages like that? One ground.
My Lord, because I have highlighted in this ground.
No.
At page it starts.
You are dealing with a review petition.
Yes, my Lord. So
You have to be very precise.
Yes, my
that
Lord.
this is the ground why review is required.
Yes, my Lord. At page 17, if I may read just the relevant part, my Lord. At page 18, my Lord.
Yes.
I'll come straight to the point at page 18. In this regard, it may be humbly submitted the review petition after obtaining the judgment. Have your Lordship found, my Lord? I'm reading from below at page 18. The last
yes,
paragraph.
I've got it.
In
Read.
this regard, it may be humbly submitted that the review petition after obtaining the judgment under review with the help of the official staff made an attempt to verify the veracity of the claim of the NBCC authorities that respondent number 8 have substantially progressed in the execution of the work in question as 8 months have elapsed and from the date of passing of the LOI, that is 31/2024. While undertaking such exercise, the review petitioner could come to learn recently on 22/9/2024.
This is what?
This is
Blank here.
my Lord, the date I have given.
Who will fill it up?
My Lord, I'm extremely sorry for that, my Lord. It was on 22nd, my Lord. Another statement I have made, my Lord. A similar statement. I'll take to your Lordship with a statement, my Lord. So, my Lord, have not even started the work to execute the work, despite the fact that 8 months have passed and from the date of issuance of the LOI. In order to fortify the above statements, the review petitioner also took few photos of the project site where the work in question to be executed and took photos of an area covering 0 to 5 kilometers in the project site and was appalled to find out that the project in question was in fact a non-starter. The review petitioner, however, could not gather the above information at the time of hearing of the writ petition, although they have exercised due diligence in as much as they were under a bona fide impression and belief that NBCC authorities, while submitting before this court relating to the progress of the work in question, would be fair in their submissions and would further produce relevant records to substantiate their stand. However, upon perusal of the pleadings of the connected writ petition, moreover, more particularly the affidavits of NBCC, the state authorities in their affidavit have not made an iota of whisper relating to the status of the work and its its progress. Afterward, after the award of the said contract to the respondent number 8, it was only at the time of the hearing of the two writ petition a submission was made by the learned counsel appearing for the NBCC authorities projecting that the work in question has substantially progressed, and this is reproduced herein below for ready reference, my lord. So this was the submissions made by them.
Now, what is the date
8, my lord, may kindly come.
that you have recently on so and so dash date?
Yes, my lord.
The respondent number 8 has not even started the execute the work.
It was on 22nd of 09, 2024.
Where have you written?
Yes, my lord. I'll just stick to that date, my lord.
22nd of
September, my lord.
September 24.
Yes, my lord.
Where have you stated that?
At page 27, my lord. 27. Ground number 4, your lordship, we'll see. Just below the first paragraph, the review petition after obtaining the judgment verified the progress of the work and discovered on 22nd 09 2024.
Oh, again, this also is blank.
My lord, we have filled it up with hand, my lord. Because the date we were not confirmed because the photos did not disclose the date, so that has to be confirmed, and then we have put the.
Then you print it and file it.
No,
You
my
file it before even knowing the date.
My lord, I'm.
Mr. Buragohain,
Yes, my lord.
what I'm saying telling you is that the thing is blank.
Oh, I'm
It's just a dash.
Sorry, my lord.
Similarly, in page 18, it's only a blank thing. Who will fill up these things?
Extremely sorry, my lord. We overlooked that part, my lord.
Who will fill it up?
In my.
And you cannot fill it up by hand also. That is not permissible.
Yes, my lord.
You withdraw and refile. What can be done?
If your lordship may allow me to, because the confirmed date is 22nd 09 in my petition, I have written.
Maybe it's not available yet.
Yes, of course.
So we don't know.
Of course, my lord. That is one aspect we have been quite, my lord. We didn't take care of it, my lord. Admittedly, my lord.
So what do you want to do?
My lord, may allow me to make the corrections, my lord. If,
How?
either, my lord.
There's a circular. You are aware of that, Mr.
Yes, my lord. That you cannot make it.
By hand, we cannot allow that.
Or if I seek your lordship permission to just amend the, or I can refile it if as your lordship has correctly pointed out, my lord.
Refile it.
Yes, my lord. Because my difficulty is that, my lord, the work even today as on date what we have learned, my lord, they have not yet started, my lord. That is one aspect of the matter which needs to be reviewed, my lord. Otherwise,
For that, I don't know whether that will come under the ambit of a review.
it will be because, my lord,
And,
these are
Whether we can
misconception of fact
we
under.
can even prima facie accept that fact without even hearing the other side. These are
my
the
lord.
aspects.
Of course, my lord, they will have to be heard, my lord. Of course, my lord. Because that part makes the entire judgment, my lord, because they did not make correct statements before this court, my lord.
So you refile. Or you want to file an application separate.
We'll file an application, my lord, perhaps just to make an amendment to this particular paragraph, my lord.
When?
And I will file, my lord. Seeking leave of this court, my lord, to insert the date, my lord.
Please write, Mr. H. Buragohain, learned counsel for the petitioner, submits that inadvertently certain dates had not been incorporated in the grounds taken in the review petition, and therefore he may be allowed to file a miscellaneous application to incorporate, for seeking incorporation of the dates. Praise the Lord.
My lord, I seek apologies, my lord, for that, my lord.
It's all right.
Obliged, my lord.
For orders, item number 8.
Yes.
My lord, the present IA is preferred to condone the delay of 88 days to prefer an appeal, my lord. And my lord,
88 days.
88 days, my lord.
Appeal against what?
Appeal against the impugn order passed in probate application number 28 of 2023, probating the will. My
Anyone
lord.
appearing for the respondent? Yes. Any objection?
Yes, my lord.
You have filed your objection? Okay. Why delay of 88 days? And what is the period of limitation otherwise?
My lord, by preferring the present application in order to prefer an appeal, this is the first appeal, my lord. And 90 days is the prescribed period of limitation, my lord. And
So 90 days has been overshot by 88 days.
yes, my lord.
What are the
After
explanations?
deducting the period of that limitation.
What is your explanation?
My explanation is that, my lord, when the impugn order was passed, the order was passed on 11 December 2023, my lord. December. During that particular period, I did not have any knowledge about the issuance of that impugn order. And after that impugn order was passed, I acquired about the issuance of that impugn order on 5 February 2024.
You came to know about this order
My lord.
dated 11/12/2023 on 5th February.
My lord.
How is that?
My lord, as soon as I acquired about the knowledge, because I received the letter from the information from the revenue authority, and as soon as I acquired about the knowledge of about the issuance of that impugn order, I applied the certified copy on that same day, my lord. The certified copy is annexed in the main appeal petition, my lord. RFA number 21 of 2024.
You applied for?
I applied for the order dated 11/12/2023, that impugn order, on 5 February 2023.
The very day you came to know
On
about
the,
it.
yes, my lord, on that day, on that very day.
It was issued to you the same day.
Yes.
Then
Then after that,
then you kept it inside your trunk and forgot about it.
not my lord.
Then
Thing is that, my lord, after I acquired about the knowledge, I filed the civil suit before the trial court, my lord, before the lower court.
you filed civil suit.
Yes, my lord.
Against
Civil
what?
suit against the
Probate?
order passed, not the probate, my lord.
Then
The order passed by the settlement officer. The settlement officer, in the light of the probate order passed by the trial court. Here,
No.
if your lordship may kindly see,
please clarify.
my lord.
After the passing of this impugn order dated 11/12/2023 granting probate
My lord.
to the respondent,
My lord.
what happened?
What happened is that
Settlement officer passed some orders.
settlement officer passed an order on 13 February 2024.
What kind of order?
Order is annexed at page 10
Of the application.
of the present application, my lord.
Page 10. Yes, what is the order?
This is the 10A is the translated copy. Here, by relying on the probate order, the settlement officer made direction to submit the original copy of the house pass within
You are
10
also
days.
a party here.
No, yes, my lord, I am also party here.
Probate was issued in favor of Lal Remzuali,
Yes, my lord.
correct?
Correct.
Appellant Ismail Somtuanga. Both of you are brothers sisters.
Yes. The
Okay.
applicant of the probate application is my elder sister. And after hereby passing the impugn order by the settlement officer, the settlement officer relied the probate order passed by the trial court, my lord.
So what did you challenge? This order?
Yes, my lord, by filing the civil suit, I challenge the order of the settlement officer before the civil
This
judge.
is under what provision? Judgment and order by the settlement officer?
Judgment and order, this is not specifically
Is
reflected.
he functioning as a court?
It seems, my lord. It is written like
Under what
judgment.
provision?
That I don't know. That is not mentioned by the order itself, my
You
lord.
were also a party there. You should know.
So after
So you challenged this before the civil court?
I challenge that before the civil court, my lord. Yes.
When? When did you file?
I filed the civil suit on 11/3, my lord.
11/3.
11/3, yes. March 11.
That is the date of the order passed by the civil court. Against the judgment and order of the settlement officer.
Yes, my lord.
What about the probate?
The
You forgot about
probate-
it.
The probate application in my civil suit petition, I had stated that appeal is to be still to be preferred before the Honorable High Court. So, in that particular after filing the civil suit, I had taken time for drafting and collecting documents to prefer an appeal against this probate impugn order, my lord. And in the meantime, I had suffered a delay of that 88 days. Thing is that, my lord. Yes, my lord.
When did you file this RFA?
RFA was filed on
10 June.
6 June, my lord. 6 June. No, 10 June. 10 June, my lord. Sorry.
So when the civil suit could be filed in the month of March, you
Yes.
filed this RFA in June. April, May, June. For three months you were collecting documents.
Yes, my
On
lord.
what basis did you file this civil suit then? You do not have the documents to file the civil suit, just like that you filed.
At the time of filing the civil suit, my lord, I am enclosing the copy of the judgment and order passed by the settlement officer. So before the trial court, the challenge was made in respect of that settlement order.
Do one
passed by
thing,
the
you
settlement
just read your explanation. We're interested on that only. Please read paragraph 3
My
of
lord.
your application.
My lord, here. The present applicant acquired the knowledge about issuance of the impugn order 11/12/2023 on 5/2/2024, wherein certified copy of the impugn order was applied to the registry of the district court on the same day. Accordingly, the applicant had acquired the knowledge that the impugn order 13/2/2024 was also passed by the settlement officer, Land Revenue and Settlement Department, Aizawl District, with the direction to the present applicant to surrender his house pass to the concerned authority of Land Revenue and Settlement. After this, the counsel representing the applicant had preferred civil suit number 24/2024, challenging the impugn order 13/2/2024, stating inter alia that the plaintiff is to prefer an appeal against the impugn order 11/12/2023 in probate application number 28/2023 before the Honorable High Court. After the civil suit was filed by the present applicant, the counsel representing the present applicant is busy with taking necessary steps for preferring an appeal petition. Whereas the counsel for the applicant had sought for a copy of all the connected documents in connection with probate application number 28/2023, the same was applied to the concerned authority of the registry of the district court. After the said documents were applied and processed, the counsel had taken time for drafting the appeal petition. During the said period, the present applicant had suffered a delay of 88 days. That is the
Are you
explanation.
convinced? Are you convinced with your own explanation? You want to convince the court with that paragraph? Are you yourself convinced? See, what happened to the civil suit? Still pending?
No, my lord.
What happened?
That rejection of plain application was filed by the defendants.
Sorry?
Rejection of plaint application was filed. Application was filed for rejection of plaint by relying that under the Mizoram Land Revenue Act 2013, orders passed by the settlement officer is to be challenged before the director of the Land Revenue Department.
Okay.
So on that basis, the suit was disposed of. Yes, my
Dismissed.
lord.
Then what has happened to that? What further process has happened thereafter?
After
Have you challenged before the director?
that,
You don't know.
that is still not done
See-
because the settlement officer has relied upon the order passed by the trial court, my lord, probating the will.
That is
That-
why. That is why when you read the order of that settlement officer, first of all, he tried to make both of you have a settlement because it's within the family. But
Yes.
since these parties were not, they were reluctant to settle, then he said the probate, there's already a probate in favor of one of the party. So let it prevail. So you were supposed to go directly and challenge the probate. Instead, you went and challenged this judgment and order passed by the settlement officer. And later on, they say that, okay, you must go to the director. That's what has happened.
So in that
So-
regard, my lord, in that regard, unless and until that
Your clients have been misled.
in that regard, if the probate order, impugn order is not challenged, my lord, before this honorable court.
It not occur to you at the first instance when you had perused this impugn order, the probate order? You could apply for certified copy on the date you came to know about the existence of this probate order. But then, at a much later point of time, you decided to apply for other materials in connection with this probate so that you can file an appeal. When was it applied? How it was given? Those particulars are not here.
This is, my lord, the only remedy available to me. And if the delay of that 88 days is condoned, and if appeal is allowed, then I have the remedy to have a fresh trial of that probate application by passing that impugn order. The will which was alleged to be made by my father was probated, because that one particular land was the only share of the family property in my favor. My elder sister,
See, whatever it may be, you cannot decide to file an appeal at your own sweet time.
that I know, my lord, that I'm
You'd
very
have to
well
take recourse to the remedies available to you
aware. That I can pay,
with
my
due
lord.
diligence. Now, in February 5th, when you came to know about this probate, you should have directly gone for an appeal or whatever remedy is available to you. You just applied for a certified copy, you were satisfied. Then came the settlement officer's judgment order, so-called judgment order. You decided to go and file a civil suit. It did not occur to you that judgment and order is based on the the probate order.
Yes, correct, my lord. And while filing the civil suit, I'm still busy with collecting documents and busy with drafting for preferring an appeal, my lord. So in that period, that 88 days, inordinate delay had inadvertently occurred, my lord.
Details of how busy you were is not available here. See, you collected the certified copy way back in February. But much later on, you decided, okay, I think we should also prefer one appeal before the High Court. Then you started collecting materials.
My lord, regarding the clarification of the delay, I had sought for permission of the coordinate bench of this honorable court to allow submission of the additional affidavit in the last court date. But that was objected and permission was not given. So if I am allowed to submit the additional affidavit, I should have made those specific period which are inadvertently not mentioned in the application, my lord. Because the possession, actual possession and physical possession of that particular land was in my favor. I have the actual and physical possession. The original copy also issued to me by my said sister. But after that, my sister, being the person who looked after my father in the main family house, had obtained that will in her favor. So due to that, she never had the physical and actual control of that property. The property is the only share of my...
Merit will come later on. We are on the condonation part. Supposing you are permitted to file additional affidavit, what will you file? What more things will you file?
My lord, that clarification of that particular period.
That you could have done at the first day itself.
Yes, my lord. That I
Why
should
should
have
you be
done.
given liberty to give you your second submission by writing? You were collecting materials. You took your own time, 88 days, to file an appeal. That was sufficient enough for you to come up with appropriate statements how the delay happened. You know very well how these things work. You may not be required to give your day-to-day explanation,
My lord.
hour-to-hour, minute-to-minute explanation, not required.
My lord.
But at least the basic reason for your delay, how it happened, that has to be there. You may draft your appeal with 20 grounds, no use, if your delay application does not have any explanation. Invariably, these are the mistakes committed by many counsels. They concentrate on the ground of the appeal, thinking that appeal will be admitted and all that. But when there's a delay, even for 15 days, if it is not explained properly, unless you overcome that delay part, how do you enter to the appeal? This is the thing. With one paragraph, you're trying to explain 88 days. How is that possible? Yes, anything else you want to say?
I'd like to rely my submission
Yes, what is that?
with the authority of the Honorable Supreme Court, my lord. Here, my lord, I'd like to rely upon the decision in State of Nagaland versus Lipok Au and others.
This is between the government and the private thing. You are not a government. How does it apply to you?
Here-
Which paragraph?
Para 12, my lord.
Para 12.
If I may read, my lord.
Yes.
Para 12. In O.P. Katpalia versus Lakshmir Singh, a bench of 3 judges has held that if the refusal to condone the delay results in grave miscarriage of justice, it would be a ground to condone the delay. Delay was accordingly condoned. In Collectoral Land Acquisition versus Katiji, bench of 2 judges considered the question of limitation in an appeal filed by the state and held that Section 5 was enacted in order to enable the court to do substantial justice to the parties by disposing of matters on merits. The expression sufficient cause is adequately elastic to enable the court to apply the law in a meaningful manner which subserves the ends of justice, that being the life purpose for the existence of the institution of courts. It is common knowledge that this court has been making a justifiably liberal approach in matters instituted in this court. But the message does not appear to have perlocated down to all the other courts in the hierarchy. This court reiterated that the expression every day's delay must be explained does not mean that a pedantic approach should be made. The doctrine must be applied in a rational, common sense, pragmatic manner. When substantial justice and technical considerations are pitted against each other, cause of substantial justice deserves to be preferred, for the other side cannot claim to have vested right in injustice being done because of an undeliberate delay. So I'd like to rely upon the principle enunciated in this decision, my lord. And also in another decision, my lord, herein Sri Devi Dattla versus Union of India and others.
Yes.
Which is at para 25 and 28. Page 334, my lord.
Yes, read.
Much later in Esha Bhattacharjee versus Raghunathpur Nafar Academy, this court referred a large number of previous judgments and observed that adoption of a strict standard of proof sometimes fails to protect public justice and may result in public mischief. Other decisions have highlighted that there cannot be a universal formula to judge whether sufficient cause has or has not been shown, and the exercise is necessarily fact-specific. In Improvement Trust versus Ujagar Singh, the court held Improvement Trust case that while considering an application for condonation of delay, no straitjacket formula is prescribed to come to the conclusion if sufficient and good grounds have been made out or not. And here, my lord, at para 28. It is evident that the term sufficient cause is relative, fact-dependent, and has many hues, largely deriving color from the facts of its case and the behavior of the litigant who seeks condonation of delay in approaching the court. However, what can broadly be said to be universally accepted is that, in principle, the applicant must display bona fides, should not have been negligent, and the delay occasion should not be such that condoning it would seriously prejudice the other party. So, my lord, I would like to rely upon this specific paragraph, which is decided by the apex court in this particular case, and in the interest of justice, my application to condonate 8 days may be allowed, failing which my other option are closed, and this is the only option I have to challenge and seek justice before this honorable court, my lord, which was passed, the probate application which was passed against me, failing which the only share I have from the family property will be confiscated from my ownership, my lord.
Will has been made in favor of the
My sister.
sister. By whom? By the mother, father?
By the father.
By the father.
In reality, that ownership was in the name of my grandfather, my lord.
Okay. And
In his favor, the title holder is not my father. It is my grandfather, but my father executed a will in favor of my elder sister, my lord.
You do not have any property of your own?
No, my lord. That is the only property I have.
Where are you staying?
Presently, I am a driver.
No, in that property only you're staying.
In that property, I have my garden. Yes, I have. I cultivate crops.
You have a garden.
Yes. At Tlangnom. Tlangnom, that
Who is staying there in the property?
In
Is
the
it an
property-
empty plot of land?
that presently it's a garden. Yes, my lord.
It's only a garden.
Yes, that is my only property. And in the main family house, my sister is living.
How do you say it's your only property? It has gone to your sister. There's a will probated. On what basis?
Prior to the presence of that that probate order, my lord.
You were looking after the garden.
Yes, I'm looking
It's
after.
not even in your name. It's not even in your father's name. It was in the name of your grandfather, like you said.
It's in the name of my father, my lord. My grandfather,
Exactly. That's what you were saying.
my lord.
And you were looking after by using it as a garden.
I am using because
But both of you are not staying there, isn't it?
Yes.
Neither of the parties staying there.
No, my lord. Not staying. My father had authorized me to look after and to have ownership of that particular plot of land also.
That's all?
That's all, my lord.
Yes, Mr. Victor.
May I please your lordship? My lord, the present applicant and the respondent were brother and sisters, as already submitted by my learned friend. And the respondent had already established separate households long time back. And the respondent alone is the one who supported and lived with the father, aged father and mother. And their mother is still alive. And this,
Who has established a separate place?
the applicant,
The applicant.
during the lifetime of the father, deceased father.
Okay.
And that property, all the properties were earlier in the name of their grandfather. But thereafter, after the demise of their grandfather, their father had obtained heirship certificate, and he was declared legal heir in respect of all the properties. And thereafter, the father had made a will dated 9/12/2020, which was duly registered under the Indian Registration Act. I have enclosed the registration certificate in my written objection at annexation number 2, page 1414. And in terms of the said will, the testator had bequeathed all the properties in favor of the respondent, his daughter. And thereafter, my lord, after that, the testator, the father, was expired on 23/2/2023, and probate application was filed in terms of the said will to seeking to probate the said will, which was allowed on 11/12/2023. And in the process of probating the said will, my lord, the learned trial court had examined all the witnesses of the will, including their mother, who is still alive and living with the respondent. It can be appreciated from the impugned order. In my written objection, my lord, page number 17. I'll go back from page to page, my lord. Page number 12, this is the will. In my written objection, page number 12, this is the will. It's in Mizo vernacular. On the following page, I have the translated copy. Page number 13. Do I have to read this, my lord?
Just read.
I, Sang Tuoma, if I ever depart from this life in an untimely manner, I will bequeath all of the landed property which is in my name, including the LSC which is in the name of my father, Patlaya, due to some reason which I cannot change the name, to my older daughter, Elder Mzoli. This is the present respondent who is taking care of me. Furthermore, my daughter, Tila Lomkimi, had brought me a letter, and she had let me press my thumbprint on it which I did not know anything written in the letter. And I would like to cancel that even though I pressed my thumbprint on it, nobody shall have the right to interrupt my will enjoyed by my daughter. And if your lordship may kindly see page number 12, turn back to page number 12. The witnesses are the chairman and secretary of local council, two of them, and one is a civilian. And on page number 14, my lord, page number 1414, annexure 2. This will was duly registered under the Indian Registration Act. This is the registration certificate of the said will, which was registered on 14th December 2020. 14th December 2020. The testator was expired after 2 years on 23/2/2023. This is the last will and testament of the testator. And while filing the probate application, my lord, there's a newspaper publication made in Wanglaini published on 10/11/2023, which I extract in page number 15. I have the English translated version on page number 16, annexure 3A, wherein 20 days period was made give for submitting an objection against the said application. And on page number 17, my lord, this is the impugn order, probate order dated 11/12/2023. Have you got it, my lord? May I read?
Yes.
This is a probate application filed by Srimati Ramazoli praying to probate the will made by his late father, Sang Thoma, dated 9/12/2020, wherein Sang Thoma executed his will in favor of the present petitioner, Ramazoli, by stating his will that I'll not reiterate this part. Coming to Para 2. The said will was executed in the presence of three witnesses, namely Zhou Sang Liana, Chairman Local Council, Tlangnum Local Council, Lalbir Liana, Secretary Tlangnum Local Council, and Aral Chang Liana, Tlangnum Aizol. The petition was published in a local daily newspaper inviting objection for 20 days. Objection has not been received till date. Copy of the local daily newspaper was also submitted in the court. Zakhumi, wife of the deceased, Sang Thoma, and the three witnesses appeared in the court and they were examined on oath. Zakhumi deposed that she has no objection to the prayer of the petitioner, who is her daughter. The three witnesses deposed that they were all present at the execution of the alleged will by the deceased and that they have appended their signatures on the will. Considering the submission of the petitioner and the publication of the petition in newspaper, examination of witnesses and the wife of the deceased, and there being no objection, this court is of the considered opinion that the will executed by the testator on 9/12/2020 is genuine and proper. Accordingly, the will dated such and such left behind by Sang Thoma is hereby probated. And subsequent to this, my lord, the respondent has been taking steps to mutate all the immovable properties left behind by their deceased father. And since one of the house pass is in the possession of the present applicant, despite requesting the present applicant several times, the applicant had refused to hand over the said house pass, and accordingly they have approached the revenue authority. And page number 20, my lord, this is the judgment order which was
How many properties involved?
their family main house and this one, my lord.
Where's the description of the property?
It's not specified here, my lord.
Then how do we know?
My lord, this from page number 20, it speaks for itself. The English version is page number 21.
This is
Judgment-
regarding House Pass 104 of 18.
Yes, my lord.
Only this one.
Only this one is which is in the possession of the applicant, which he alleged to have been utilized as a garden.
And what about the other property as per this will?
That are not in dispute. The family main house where they were residing.
No, what do you mean it's not in dispute? This will
He
as
is claiming only this particular property. The applicant is claiming only this particular property out of the other properties.
maybe, but this will includes everything, isn't it?
Correct, my lord.
What are those?
So far as my knowledge is concerned, this particular property and the family main house, wherein they are presently residing,
It's covered by LSC.
LSC.
And the garden which he is using is covered by House Pass.
House pass mutated in the name of the testator.
Anyway, those are the factual submissions.
Yes, my lord.
What do you say about the delay part?
If I
We are on
may-
delay, in fact, today.
Yes, my lord. If I may take a lordship again to page number 21, my lord, I would like to emphasize certain points on this.
21,
21 of my written objection.
judgment and order.
Yes, my lord. This was issued by the settlement officer on 13th February 2024. May I read?
Yes.
Srimati Lorem Zoli, daughter of Sangtrom, and her brother Malsom Tluanga, had discussed the dispute over House Pass number 104 of 2018 in the Revenue Court on 18/1/2024 in the presence of settlement officer. My lord, here they had already discussed about this issue on 18/1/2024, and only as a result of the existence of the probated will that these rival parties have misunderstanding, and it resulted in approaching this revenue authority. Although this judgment order was issued only on, this is the subsequent stage after they failed to make any settlement between them. It was issued on 13/2/2024. But from bare perusal of this order, my lord, it is apparent that on 18/1/2024, the applicant was already aware of the fact that there was probate order in favor of the respondent. In spite of this, my lord, the applicant had claimed to have came aware the existence of the impugned order only on 5/2/2024. And not only that, my lord, the applicant failed to explain how did he came to aware of this impugned order. He merely stated that he had applied for certified copy on 5/2/2024. In view of this judgment order passed by the settlement officer, it is apparent that he was already aware of the existence of the impugned order on 18/1/2024. Meaning thereby, my lord, the applicant does not approach this honorable court with clean hands, my lord.
Now, how do you say that he already knew about this on 18/1/2024?
Yes, my lord.
How?
They were fighting over this for this house pass so and so.
They were fighting over it, but where does it say that there's a what do you call probate? Will probate in favor of the one of the party?
It's all on the following paragraph, my lord. It's all written here. Third paragraph, we have to read everything in its entirety.
There's something mentioned in the second paragraph.
Yes, my lord.
Letter dated 8/2/2024.
This was subsequently submitted by the respondent, informing the revenue authority that they could not settle their dispute amicably.
Yes, whatever it is, you have the copy of this letter?
Not
What you are trying to project is that on 18/1/2024, applicant was already aware about the probate.
yes, my lord.
So this letter might throw some light on it. This is your letter. If not 18/1/2024, it will be 13/2/2024, the day of passing this judgment in order.
Yes, my lord.
Anyway,
According to him, my lord, according to the applicant, he came to aware this impugn order on 5/2/2024, but he failed to explain how he came to aware of the existence of the impugn order, my lord. He merely stated that he had applied for certified copy on 5/2/2024. He had Part 3 in his application, my lord. Part 3 in his application, my lord. He had stated that the present applicant acquired the knowledge about issuance of the impugn order on 5/2/2024, wherein certified copy of the impugn order was applied to the registry of the district court on the same day. And besides that, my lord, the other grounds taken by the applicant is that after coming to aware this impugn order, as well as the order passed by the settlement officer, he had taken steps, but he failed to mention when did he approach his counsel, when did he give instruction to take necessary steps in this regard. He failed to mention that. And moreover, my lord, within this paragraph 3, the other grounds taken was that they have taken time for collecting documents, but they failed to mention on which date the application for copy of these such documents was submitted and when it was furnished to them. All those things were not mentioned, my lord.
that's all. Anything else?
And in the civil suit, my lord, which was filed by them, my lord, as already submitted by my learned friend, I have also enclosed the copy of the order which rejected the plaint.
I've seen it.
Yes, my lord.
Now, what about the any attempt to go to the director?
It is for them to approach the director, my lord. We have no
It is
grievance
for
with
them, I know. Have they approached the director?
So far as my knowledge is concerned, nothing is there, my lord. They have not taken any steps as of now. And the only allegation, the only contention made by them in the said civil suit in respect of this house pass was that it was gifted to him. But there was no any valid instrument in his favor. It's only a verbal.
Yes.
And the applicant has been on his own since 2001. And at present, my lord, the said particular land, he's interested only in respect of this house pass, and which was never in his name. And assuming for the sake of argument without omitting it by note, even though this will did not exist, he has no right to involve in this property because besides the present respondent, my lord, their mother is also still alive. So, my lord, my humble submission is that the applicant have not approached this honorable court with clean hands, and there is no proper explanation, and he has not acted diligently. And in support of my submission, my lord, I would like to place my reliance on the authority reported on 2013, Volume 2, SCC, page number 398, para 32. Para 32. The case of abuse of process of court and such allied matters have been arising before the courts consistently. This court had many occasions where it dealt with the case of this kind and has clearly stated the principles that will govern the obligations of a litigant while approaching the court for redressal of any grievance and consequence of abuse of process of court. We may recapitulate and state some of the principles. It is difficult to state such principles exhaustively and with such accuracy that would uniformly apply to a variety of cases. These are: courts have, over the centuries, frowned upon litigants who, with intent to deceive and mislead the courts, initiated proceedings without full disclosure of facts and came to the courts with unclean hands. Courts have held that such litigants are neither entitled to be heard on the merits of the case nor are entitled to any relief. The people who approach the court for relief on an ex parte statement are under a contract with the court that they would state the whole case fully and fairly to the court, and where the litigant has broken such faith, the discretion of the court cannot be exercised in favor of such a litigant. The obligation to approach the court with clean hands is an absolute obligation and has repeatedly been reiterated by this court. Quests for personal gains have become so tense that those involved in litigation do not hesitate to take shelter of falsehood and misrepresent and suppress facts in the court proceedings. Materialism, opportunism, malicious intent have overshadowed the old ethos of litigative values for small gains. A litigant who attempts to pollute the stream of justice or who touches the pure fountain of justice with tainted hands is not entitled to any relief, interim or final. The court must ensure that its process is not abused, and in order to prevent abuse of process of court, it would be justified even in insisting on furnishing of security, and in case of serious abuse, the court would be duty-bound to impose heavy costs.
How do you say there's been abuse of process of court
My
in
lord,
this case?
from bare perusal of the revenue order, which I have already placed, my lord, it transpires that on 18-1,
He knows that there's
he
a
knows that
probate.
there's a probate order. And
Anything else?
yes, my lord, 2013, volume 14, SCC, page 81.
Paragraph?
11, 12, 13, 14, and 15. Para 11, the expression sufficient cause should be given liberal interpretation to ensure that substantial justice is done, but only so long as negligence, inaction, or lack of bona fides cannot be imputed to the party concerned. Whether or not sufficient cause has been furnished can be decided on the facts of particular case, and no straitjacket formula is possible. It is a settled legal proposition that the law of limitation may harshly affect a particular party, but it has to be applied with all its rigor with weighing the statute so prescribes. The court has no power to extend the period of limitation on equitable grounds. A result flowing from a statutory provision is never an evil. A court has no power to ignore that provision to relieve what it considers a distress resulting from its operation. This statutory provision may cause hardship or inconvenience to a particular party, but the court has no choice but to enforce it, giving full effect to the same. The legal maxim, dura lex sed lex, which means the law is hard, but it is the law, stands attracted in such a situation. It has been consistently held that inconvenience is not a decisive factor to be considered while interpreting a statute. Para 15. The law on the issue can be summarized to the effect that where a case has been presented in the court beyond limitation, the applicant has to explain the court as to what was the sufficient cause, which means an adequate and enough reason which prevented him to approach the court within limitation. In case a party is found to be negligent or for want of bona fide on his part in the facts and circumstances of the case, or found to have been not acted diligently or remain inactive, there cannot be a justified ground to condone the delay. No court could be justified in condoning such an inordinate delay by imposing any condition whatsoever. The application is to be decided only within the parameters laid down by this court in regard to the condonation of delay. In case there was no sufficient cause to prevent a litigant to approach the court on time, condoning a delay without justification, putting any condition whatsoever, amounts to passing an order in violation of the statutory provisions, and it tantamounts to showing utter disregard to the legislature.
That's all?
So, my lord, yes, my lord. So the applicant failed to make out sufficient cause in explaining the delay, and the instant application may be dismissed.
Any reply?
Lord, only thing which I'd like to reply is that with regard to the submission made by my learned friend, that I am living in a separate residence. Actually, my present condition is that I am still a bachelor and I am a driver living in the house of my master. I am engaged for the last more than 10 years, my lord. So I'm living in their house. I do not have a separate house of my own. So that is what I like to mention. And with regard to acquiring knowledge on 18/1/2024, that was only a discussion. On that particular day, I do not have the knowledge about the presence of that probate order, my lord. Only a summon was received from the revenue department, and discussion was made on that particular day, 18 January. But I do not have the knowledge about the presence of that probate order, my lord. That is the clarification I'd like to make, my lord.
Okay. Please write. Heard Mr. F. Lal Engliana, learned counsel for the applicant, and Mr. Victor L. Ralte, learned counsel for the sole respondent. Stop. Next para. By filing this application, the applicant seeks condonation of 88 days in filing the connected regular first appeal against the order dated 11/12/2023. Passed by the Court of Civil Judge, Senior Division 3, Aizawl, District Aizawl, in probate application number 28/2023. Whereby the will dated 9/12/2020, executed by Sri Sangtuama, was probated in favor of the respondent. Stop. Next para. Be it stated herein that the applicant and the respondent are siblings, and that late Sri Sangtuama is their father. Who is said to have left behind the properties in question in favor of the respondent through the said will. Stop. Next para. It is the case of the applicant that Sri Sanctuama when did he die?
23 to 2023.
Expired on 23 to 2023. And the applicant came to know about the probating of the will dated 9/12/2020, white order dated 11/12/2023, only on 5/2/2024. Stop. He then immediately applied for a certified copy of the said order on the same day. To stop, the applicant also came to learn about the order dated 13/2/2024, passed by the settlement officer, Land Revenue and Settlement Department, directing the applicant to surrender the house pass to the revenue authority concerned. Against the order passed by the settlement officer dated 13/2/2024, filed civil suit number 24 of 2024. And at the same time, made preparation for challenging the order dated 11/12/2023, passed in probate application number 28 of 2023 before the High Court. By applying for all the connected documents in connection with the probate application before the registry of the district court. Stop. After collecting all the required documents, the applicant was able to file the connected regular first appeal and the instant application only on 10/6/2024. Stop. By that time, a delay of 88 days had occurred, and therefore the instant application is filed seeking its ITS, its condonation. Next para, Mr. F. Lal Yangliana, learned counsel for the applicant, submits that the applicant came to know about the order passed in the probate application only on 5/2/2024. And immediately applied for a certified copy of the same. Stop. At the same time, the settlement officer passed the order dated 11/12/2023, directing the applicant to hand over the house pass to the revenue authorities. Stop. Against the said order, the petitioner, the applicant, filed civil suit number 24 of 2024. And at the same time made preparation for filing an appeal before this court against the order passed in the probate application. Stop. Since the applicant did not have all the required documents, he applied for the same before the registry of the district court concerned. Not concerned, the registry of the district court. Which therefore has resulted in the delay of 88 days in filing the connected appeal. Stop. He submits that the delay is unintentional and due to bona fide reasons, and therefore the same may be condoned. Stop. He also submits that the applicant has no other remedy against the order passed in the probate application and therefore court may condone the delay so that the applicant can avail for the only remedy available. Stop. He further submits that the applicant has been looking after the land covered by the house pass by using the same as a garden for cultivating vegetables, etc. Stop. In other words, the learned counsel submits that even on merit, the applicant has a good case and for which the delay should be condoned. Stop. In support of his submission, the learned counsel has relied upon the following authorities, column dash. Number 1, Sri Devi Datlal. I'll repeat, Sri Devi Datla versus Union of India and others. 2021, 5 SCC 321. And number 2, State of Nagaland versus Lipok Ao and others. 2005, 3 SCC 752. Next para, Mr. Victor L. Ralte, learned counsel for the respondent, on the other hand, submits that it is clear from the order passed by the settlement officer, Land Revenue and Settlement Department on 13/2/2024 that the applicant was indeed aware about the order passed in the probate application to stop. The applicant therefore has not come before this court with clean hands by stating that he came to know about the order passed in the probate application only on 5/2/2024 without substantiating the same in any manner. Stop. Next para, the learned counsel further submits that the order passed in the probate application was preceded by a notice issued in the local daily giving opportunity to any interested person to have a say in the application for probate submitted by the respondent. Stop. However, within the time given for making an objection, no one had appeared before the court, and the respondent on her part, examined, produced, not examined, I'll repeat, the respondent on her part produced 3 witnesses who were the signatories to the will concerned and one of them was her mother.
4 witnesses, 3 plus 1. 3 are witness in the will plus mother. All of them are 4.
What did I say? No, and one of them, you cancel that. And one of them not required. Who are the witnesses to the will concerned? Apart from producing her mother as well. Stop. It was only then that the probate court had granted probate of the said will to the respondent. Next paragraph, the learned counsel also submits that the respondent had looked after her parents including no, you cancel that. The learned counsel also submits that the respondent had looked after her father during his lifetime, along with her mother. Whereas the applicant had moved out from the house. So therefore, the applicant cannot have any claim to the property left behind by her late father, even otherwise. Full stop. The learned counsel submits that the applicant was not only aware about the issuance of the probate to the respondent, when hearing was conducted before the Revenue Court on 18/1/2024. You please cancel from the learned counsel submits that paragraph, okay? Let us rewrite again. Make it a fresh paragraph. The learned counsel further submits that even assuming that the applicant was not aware about the order passed in the probate application on 18/1/2024. Please read the sentence. Comma. But he was indeed aware about the same when the order dated 13/2/2024 was passed by the settlement officer, Land Revenue and Settlement Department. Stop. Despite the same, the applicant has failed to approach this court. Soon thereafter, as such, there is no basis on the stand taken by the applicant that the delay in filing the connected appeal is unintentional and for genuine reasons. Stop. He submits that the explanation given by the applicant for condoning the delay of 88 days is far from being satisfactory, since he has failed to mention on which date he had applied for copies of the connected documents in respect of the probate application number 28 of 2023. So the applicant has also failed to mention cancel the last paragraph. Last line. The application has failed to mention it like that. Stop. He therefore submits that the applicant has failed to demonstrate any bona fides in filing the appeal, connected appeal, beyond the period of limitation. But by not only failing to give reasonable explanation, but also by not coming to the court with clean hands. Stop. As such, the delay of 88 days may not be condoned and the application should be dismissed. Next para. Not next para, same para. In support of his submission, the learned counsel has relied upon the following authorities. Number one, Kishore Samrait versus State of Uttar Pradesh and others, 2013, 2 SCC 398, and number two, Basavaraj and another versus Special Land Acquisition Officer, 2013, 14 SCC 81. Next para. I have heard the submissions made by the learned counsels for the rival parties, and I have perused the materials available on record, including the authorities relied upon by them. Stop. By filing this application, the applicant seeks condonation of 88 days in filing the connected regular first appeal. To stop. Office note dated 11/6/2024 indicates that upon a calculation made by the registry, the delay is for 90 days and not 88 days. Stop. Whatever the reason whatever the number of days of delay may be, what this court is required to consider is as to whether the delay has been explained with sufficient cause. Stop. In order to appreciate the explanation given by the applicant, paragraph 3 of the application may be abstracted hereunder. As the same is basically the paragraph which deals with the explanation of the delay. Paragraph 3, okay, page 3. It's a yellow flag. Next para. From the above abstract, it may be seen that, according to the applicant, he has come to learn about the order passed in the probate application on 5/2/2024. Stop. Such information or knowledge, cancel that such information. Stop. The applicant has, however, not disclosed as to how and from whom has he come to learn about the order passed in the probate application. Stop. According to the respondent, the applicant was aware about the order passed in the probate application as on 18/1/2024, where a discussion had been held before the revenue court presided over by the settlement officer, Land Revenue and Settlement Department. Stop. A perusal of the order passed by the settlement officer on 13/2/2024 although does not disclose the fact that the applicant was aware about the order passed in the probate application, but the fact remains that the said order dated 13/2/2024 provides that as the parties were unwilling to settle the dispute between themselves, it was decided by the settlement officer that the dispute be solved as per the will already probated by the civil code. Stop. Against the order dated 13/2/2024 passed by the settlement officer, the applicant filed civil suit number 24 of 2024. And the same was admitted and summons issued to the defendants concerned, white order dated 11/3/2024. Stop it. However, transpires that the suit was subsequently disposed of by the civil judge white order dated 26/7/2024. With an observation that as the plaintiff had approached the revenue court, which passed the order dated 13/2/2024, the plaintiff should approach the appellate authority as per the relevant provisions of the Mizoram Land Revenue Act, 2013. Stop. Next para. It may be noticed here in that it is not the case of the applicant that he seeks condonation of delay for having approached the wrong forum. Stop. according to the applicant, even as civil suit number 24 of 2024 was being filed, the applicant was making preparation to file an appeal against the order passed in the probate application. Stop. While the civil suit would be filed, on 11/3/2024, the applicant was unable to file the connected appeal, and the reasons cited in the application is that a copy of all the connected documents in connection with the probate application was being applied before the concerned authority in the registry of the district court. Stop. The applicant has, however, not disclosed as to when the same was applied and what documents were applied for and when the same was handed over to him. Stop. The explanations tendered in paragraph number 3 of the application as abstracted herein above therefore only appears to be incomplete and sketchy. Next para, you cancel that. Reliance has been placed upon the case of State of Nagaland versus Lipok, Au and others. More particularly, paragraph 12 of the said judgment. Stop. In paragraph number 12 of the said judgment, the apex court had referred to another case of the same court, namely O.P. Katpalia versus Lakmir Singh, 1984, 4 SCC 66. Where the court had held that where the refusal to condone the delay results in grave miscarriage of justice, it would be a ground to condone the delay. Stop. The expression within inverted comma, sufficient cause, close inverted comma, is adequately elastic to enable the court to apply the law in a meaningful manner, which subserves the ends of justice. And therefore, a justifiable liberal approach should be adopted. Stop. Coming to the present case, it may be seen that the applicant was aware about the order passed in the probate application when the matter was taken up before the revenue court. Revenue court, you cancel, before the settlement officer, Land Revenue and Settlement Department. If not on 18/1/2024, but surely with the passing of the order dated 13/2/2024 by the revenue court, by the settlement officer. So despite the same, although the applicant initiated civil suit number 24 of 2024, but he has filed the present connected appeal only on 10/6/2024. Stop having regard to the statements made in paragraph number 3 of the application. The applicant has only failed to demonstrate that there was sufficient cause which prevented him in not approaching this court on time, and at least and if not at least soon after the passing of the order dated 13/2/2024 by the revenue court, by the settlement officer. Next paragraph. Reliance has also been placed to the case of Sri Devi Datlal Supra, wherein the apex court, in the given facts of that case, held that there is no straitjacket formula prescribed to come to the conclusion as to whether sufficient and good grounds have been made out to condone the delay. Stop. The same has to be judged amongst others from the behavior of the litigant who seeks condonation of delay, and who should display bona fides, and that there should not be any negligence. In approaching the court. At the earliest. Stop. As already stated herein above, the applicant, besides stating that preparation was being made to prefer an appeal before the court, before this court, by applying for all the connected documents before the lower court, has not given any details or substantiated such a stand. Stop. Therefore, it only appears that there has been negligence on the part of the applicant to approach this court soon after he came to learn about the impugn order on 5/2/2024. Next para, the apex court in Basawaraj and another Supra. In paragraph number 12, 13 and 15, which are being abstracted hereunder, held as follows. Please abstract this, okay? Page 86, 87 and 88 of this Basawaraj. Next para, from the above abstract, it may be seen that it is the duty of the courts to exercise its powers judiciously based on the facts and circumstances of each case, and that sufficient cause, that is within inverted comma, cannot be liberally interpreted if negligence, comma, inaction or lack of bona fides is attributable to the party concerned. Stop. Even though limitation may harshly affect the rights of the party, but it has to be applied with all its rigor when prescribed by the statute. Stop. courts do not have the power to extend the period of limitation on equitable grounds. Stop. Next para. Therefore, upon due consideration, this court is of the considered view that the applicant has failed to demonstrate bona fides in filing the instant application, and while giving satisfactory explanation for condoning the delay. So accordingly, the application stands rejected. Then, in the main appeal, in view of the order passed today, in IAC number 101 of 2024, the appeal also stands dismissed.
Deeply obliged.
I think we should. Yes.
My lord, this is item number 9.
It has not been called out.
Yes, yes.
You are in a hurry.
No, lordship, not in a hurry.
What is it? Why is it listed for today?
My lord, this is also an application for condonation of delay of 861 days.
Okay, and there's an objection already filed?
No, objection has not been filed, man.
My lord,
You have no objection?
my lord, there is an attempt on the part of the parties to come to an amicable settlement.
They are in a cordial relationship, my lord. They live in one colony, so they want to enter into a settlement.
Okay, you want to make an attempt?
They have already attempted, my lord. We have to only draft the settlement agreement. Today in the morning, they called up with all the terms and everything, my lord.
No, what is to be done by this court
So,
now?
my lord, perhaps, my lord, maybe.
You want some time?
Yes, my lord. Adjourned, and then we'll submit the settlement.
Please write down. Parties are represented by their respective counsels, and they submit that an attempt is being made by the parties for settlement out of court, and therefore the matter may be adjourned. Stop. In view of above, matter stands adjourned for
2 weeks, my lord.
2 weeks. As prayed for.
Obliged.
I'll just come back in 5 minutes.
if I may be allowed to read.
Yes, read.
Referring to letter dated such and such, Under Secretary DPNAR may kindly find here with salary head of accounts in respect of all employees under GAD SAW for information and further necessary action. My lord, this code is the Treasury budget code, and the petitioner will be drawing his salary from the budget code 090 Secretariat.
So you need not worry about your salary. You'll be getting it.
I've not gone through it as in your.
And my lord, I want to make some clarification that the post of joint secretary is not a non-existent post. In fact, my lord, I have filed my affidavit.
See,
in
we'll do one
opposition-
thing then. You file this in the form of an affidavit.
Yes, my lord.
We'll consider it.
But my lord, in the last court date, I was not directed to file the.
No, today, like since you have produced it, and you say that you want to make some further clarification.
No, my lord. It's already stated here in my affidavit in opposition.
Okay, then it's okay. This you file in the form of an affidavit.
Yes,
We'll
my
take
lord.
it up again. Ms. Caroline K. Lungoipui, learned government advocate, has received the instructions. Stop. On perusal of the same, let the same be filed by way of an affidavit, additional affidavit. And for which, how much time?
My lord, I can file it tomorrow.
2 days' time is granted. Today is what? Have list again on Thursday.
Membership may kindly listed next week also. I have some personal difficulties. Monday, 25th.
Monday, Tuesday will be difficult.
If it can be listed on 22nd of November, my lord.
27.
22nd. This
Friday?
coming Friday, yes, my lord.
My junior is getting married.
22nd.
Anytime next week.
28 then.
I'm okay.
List the matter again on 28th of November 2020. Interim order passed salary continue till then.
Item number 3.
My lord, I am appearing on behalf of the state respondents number 1 and 2, and we will not be filing any affidavit in opposition.
1 and 2.
Yes, my lord, 1 and 2.
Okay. What about others? Huh?
3.
Okay. Yes.
I not yet received any instruction till date. I may not be filing my application.
Okay.
My lord, I'm appearing for respondent number 3.
Hmm.
We will be filing this week.
When?
This week.
This week. You have already filed. 4, 5. Please write. The parties are represented by the respective councils. Stop. Ms. Caroline K. Lungoipui, learned government advocate, submits that respondent numbers 1 and 2 will not be filing counter affidavit. Stop. Similarly, Ms. Zaram Sangpui, who appears for respondent number 4, submits that respondent number 4 will not be filing counter affidavit. Stop. Mr. Samuel Banushi Rachangte, learned counsel, appears for respondent numbers 5 and 6 and submits that the respondent numbers 5 and 6 have already filed their counter affidavit. Stop. Mr.
LS Lalram Suwana.
Sorry?
LS Lalram Suwana.
Mr. L.S. Lalram Suwana, learned counsel, who appears for respondent number 3, submits that counter affidavit will be filed within the course of the week. In view of above, list the matter again after a week.
My lord.
in the admission column.
Obliged.
Item number 4.
My lord, in this matter, may I seek for further 3 weeks' time to file reply affidavit against the affidavit of positions of the respondents.
Yes, parties are represented by the respective councils. Stop as paid for by Mr. B. Ramega, learned counsel for the petitioners. Further 3 weeks' time is granted for filing affidavit reply. List again after 3 weeks.
Much obliged.
Item number 5.
My lord, I am appearing on behalf of the said respondents number 1 to 6. I have received the perverse comments. However, some of the annexures are illegible, my lord. So, if I may be granted another 2 weeks' time.
Okay. Mr. Lianshuma,
No objection, my lord.
parties are represented by the respective councils. Stop. The learned government advocate submits that Parawai's comments have been received, but as the annexures are not legible, she has sought for legible copies of the same. Stop. She therefore submits that further 2 weeks' time will be granted for filing the counter affidavit. Prayers allowed.
Obliged.
Obliged.
List again after 2 weeks.
Item number 6.
May it please, my lord. Your lordship, we filed the additional affidavit this morning, my lord, and we have served a copy to the council.
So Samuel Vanushi at the Sangtel on an additional AG submits that additional affidavit has been filed this morning and copy has been served to the opposite party. Stop. It is, however, seen that the same is not on record and therefore office to verify and connect it the same and to connect the same to the record. List the matter again
In the coming week.
after a week.
Obliged, my lord.
Item number 7.
Lordship, as per the last order, the notice was served to the sole respondent by way of Dusty on 28 October 24, and for the proof of that, affidavit was filed.
Who's respondent number 4?
No, only one respondent,
Who is he?
Jacob Lalpek Lua.
What is the case about?
This is about Lok Adalat Award. Challenging Lok Adalat Award.
Why? On what basis?
On the basis of that, at the time of sitting, the petitioner was not present. However, a word was made.
Okay, we'll fix it after a week.
Yes.
All right.
Yes, yes.
Recently, there's some case decided also by a court and bench. Are you aware?
Yes. No, no.
He said yes, again no. Just find out. It might help you also.
Yes. That's it.
Mr. K. Thang Remsang, learned counsel for the petitioner, submits that notice has been served to the sole respondent by way of Dusty. And the petitioner has filed an affidavit as proof of service. Stop. Upon perusal of the said affidavit, filed on 6/11/2024, notice upon the sole respondent is accepted as to be as complete. Stop. However, as no one appears for respondent number, no one appears for the sole respondent.
And Lordship, may I get to maintain the stay of execution number 24 of 23?
Yes. Let the matter be listed again after a week. Stop. In the meantime, the interim order passed earlier shall continue till the next date of listing.
Obliged.
For hearing, item number 10 and 11.
What is this matter, Mr. Malhotra? Is it a lengthy matter?
It will take some time, right?
It will take some time. The reason is that afternoon we might have some problem. Series of meeting coming up.
The basic dispute is regarding seniority of promotees and direct recruits. And
What post? What kind of service?
MCS junior grade.
Okay.
And there are three judgments of the Honorable Supreme Court involved. And the first was NR Parma's case, where the Supreme Court has held that the initiation of selection process will be the date from which seniority should be counted. Not the date of appointment, the date of initiation of selection process will be the date from which seniority is to be counted.
You're relying upon that.
Yes.
Now, supposing if you don't have service, then how do you count the date?
No,
You were not actually appointed on that
yes,
date.
but Your Worship, according to NR Parma's case, that when the requisition was sent for either direct recruitment or promotion, that is the date from which seniority has to be counted. That is the law laid down by NR Parma's case. Subsequently, Megha Chandra's case was decided by the Supreme Court, which set aside NR Parma's case, but with prospective effect. So all those matters which were settled in accordance with NR Parma's case remained untouched, and Megha Chandra's judgment came later on, and which had only prospective effect. But subsequently, another judgment of the Honorable Supreme Court has come, and it's called Harichandran's case, where Megha Chandra's judgment has been referred to a larger bench for reconsideration, saying that a constitution bench judgment as well as a full court judgment was not placed before the Honorable Court while deciding Megha Chandra's judgment. So, according to Hariharan's judgment, Megha Chandra's judgment has been referred to a larger bench for rehearing.
Okay. Any interim order operating
No.
as of today?
No.
Your basic claim is to have that seniority,
Yes.
so that you can be considered for
We are,
further
we are,
promotion.
we are promotees. The case of the petition is very simple, Your Worship. The selection process was initiated in 2010-11, and requisition was sent by the DPNAR to MPSC for making selection for direct recruitment as well as induction. But then subsequently, the DPNAR sent a letter to the MPSC to cancel the induction process, and they went ahead with the direct recruitment process.
So direct were recruited first.
Yes. And then the cancellation of the induction process was challenged before this Honorable Court, and this Honorable Court set aside the instruction for cancellation of induction process. Accordingly, the matter was carried on, selection process was continued, and the petitioners were inducted in 2015.
At a later point of time.
At a later point of time.
But since it was set aside, you claim that it should be from the date of initiation.
Yes, as per NR Parma's case.
Okay.
And now the government, the state respondents have held that we have followed NR Parma's case, but now it's regarding interpretation of NR Parma's case. And the instruction issued by the government of India regarding seniority of direct recruits and promotees on the basis of NR Parma's case. Because we are challenging the seniority list of 2018, and Megha Chandra's judgment came out only in 2019. So our contention is that we are covered by NR Parma's case.
Okay, both cases are similar?
Facts are slightly different, but the law is similar. Both have challenged the same seniority list. There are two sets of promotees.
I see. And Mr. Bila Ramanga is for all the private respondents?
Yes, my lord, but except other 3-4 private respondents, my lord.
They have
I'm
not come?
presenting, yes.
Any order passed
No,
regarding the service to be completed and all that?
There is no interim order, my lord.
No, not interim order. Regarding notice.
Yes,
Regarding
all are complete, my lord.
Notice is complete.
Yes.
So Mr. JC is for the MPSC?
Yes.
And you're for the government?
It will take time, I think, my lord. This will be a lengthy matter.
Today will not be possible to take up this matter. We can have it maybe on Thursday.
if it may come upon next week, my lord, any
Next
day.
week?
Yes, because I have some fixed matters, in fact.
Your ship is here only till next week. That is
Next week, there also, I'm not fixing any matters on Monday and Tuesday.
Your ship, we can start
Monday
off on
also.
Thursday. I mean, by the time I finish, my learned friend will have enough time.
We have fixed matters. That is the problem, my lord.
You never know, it might get adjourned.
I can start on Thursday. Then your lordship is here next week also. They can give their reply.
My lord, I also have prior engagement on Thursday.
We both have an item fixed for hearing on Thursday in another court.
So I can start off.
But we also should hear it.
Monday.
Basically, it'll be a DB day, but if the matters are less, we can start with the.
We can start off tomorrow. Your Lordship, it's a long pending matter, and because promotions of the private respondents has carried on, so it's going to complicate matters further if the matter is delayed further.
No, if the parties cooperate, you see, if you can bring out the broad facts of the case
Yes.
in a brief manner, then what is the law involved?
I'll try to do it tomorrow after DB.
All matters, in fact, the dispute revolves around only a few points.
Yes.
But then submissions becomes a bit lengthy, then you tend to forget what was submitted and what was not.
Tomorrow I have another fixed item, my lord.
Friday I start.
Fortunately, we have 3 courts now.
Yes.
And probably tomorrow, most of the matters will go to the other courts. And apart from pronouncement of one judgment, perhaps we will have more time if the party agrees.
The problem is then, my lord, I have fixed item in court number 1 tomorrow.
DB?
Yes, after DB.
After DB?
Yes.
The DB will take some time. DB is the priority. It's a part-heard matter.
No, my lord.
If
It
it's
is
not a
fixed
part-heard matter, huh?
Fixed matter, my lord.
No,
We
it's not a
prayed for
part-heard.
adjournment. Yesterday we prayed for adjournment, but it wasn't allowed that it should be taken up tomorrow. Direction was given in that way.
Thing is that if you start your arguments here, somebody can always mention that you are on legs, isn't it?
I don't know whether Mr. Jesse could accommodate on this coming Thursday. Thursday, if my learned friend could start, then maybe.
Your Lordship, in fact, if my learned friend will agree, the MPSC have not filed any affidavit. They have not taken any stand. My learned colleague, Mr. JC.
If we could try on Thursday, maybe
Thursday.
it would be better.
Mr. Jesse, you have any problem with Thursday?
My lord, that's actually I have to go to Lunglei. So I'll be on journey on the whole day. Right from Delhi, I have to leave the early morning from Delhi.
They have not filed any affidavit also.
No, are you going to make any submission on this case?
It depends on the argument.
No, but you have not filed any affidavit.
Yes, of course.
We can start off on Thursday.
We'll start off on Thursday, then you can make your, but
Yes.
you ask one of your juniors to be there, who will take notes regarding their submission, and you can make a reply on some other day, if you want to.
Yes, yes, Your Lordship.
Thank you. Thursday.
In fact, we could start tomorrow also, if that's the case.
If possible, my lord, if it could be started from Thursday, so that I'll be there in the courtroom.
Okay, okay. As agreed to by the parties, let the matter be listed again on Thursday
I'm online.
for hearing.
Item number 13.
13 is Mr. Bilaramaga's case. Mr. Bilaramaga, this is also your case.
Sorry, my lord.
13.
My lord, if this may come up after a week, because I thought that the other item may be taken up. Item 13.
As prayed for by Mr. Bilal Ramega, learned counsel for the appellant. List the matter again after a week.
Much obliged, my lord.
I'm online.